Welcome to This Explainer. Today, we're diving into a landmark 1999 South African constitutional court case that exposes the very real-world consequences of a legal system that basically assumes you're a criminal from the get-go. We usually think of justice as this blindfolded figure holding perfectly balanced scales, right? But what happens when the scales are rigged by the law itself, and then the paperwork just completely vanishes? Today, we are looking at the fascinating and frankly shocking case of State versus Manyonyo. So let's jump straight into this fundamental tension and ask ourselves a pretty chilling question. Can the law actually presume you are guilty? In modern democracies, we take the phrase innocent until proven guilty totally for granted. It's the absolute bedrock of fairness. But there was a time in South Africa when specific laws were designed to do the exact opposite, effectively forcing the accused to prove their own innocence against some pretty enormous odds. To make sense of all this, we're going to break this explainer down into 4 quick chapters: convicted by presumption, the bureaucratic black hole, the constitutional clash, and finally, the final verdict. All right, Chapter 1, convicted by presumption. Let's wind the clock back to the deeply flawed 1995 trial of Mr. Manyonyo in the magistrate's court. This is where the scales of justice first tipped heavily against him. The number you need to know here is 42. In July of 1995, Mr. Manyonyo was quickly sentenced to 42 months in prison for dealing dagga, or marijuana, with 18 of those months conditionally suspended for 5 years. On the surface, it just looks like a standard conviction. But when we pull back the curtain on exactly how the magistrate arrived at this 42-month sentence, the foundational flaws of the case become glaringly obvious. Here's the crazy part. He wasn't actually caught dealing. There was no sting operation, no money changing hands witnessed by police. Nope. Instead, the magistrate relied on this very specific legislative trap from the Drugs and Drug Trafficking Act of 1992, Section 21, subsection 1C. This rule essentially said that if the prosecution could just prove you conveyed or transported a drug, the law automatically presumed you were dealing it. Just like that, the burden of proof shifts entirely. The state doesn't have to prove you're a dealer, you have to prove you aren't. And that brilliantly illustrates just how aggressively these old laws stacked the deck against an individual before a trial even started. I mean, the magistrate didn't just stop at the presumption of dealing. They also brought in Section 20 of the same act, which dictated that if a drug was found in your immediate vicinity, the law automatically presumed you possessed it. So think about that. Simply standing near something illegal meant you possessed it. And if you moved it, well, now you're dealing it. You can see how fast someone could get swept right into a conviction without the state ever actually proving criminal intent. Which brings us to Chapter 2, the bureaucratic black hole. Normally, a conviction like this gets sent out for automatic review by the Supreme Court. It's standard procedure, designed to be a safety net. But instead of a safety net, Mr. Manyonyo hit a brick wall. Think about the stark contrast here. He gets convicted with lightning speed in July of 1995, but the trial record doesn't even reach the reviewing registrar until December. The review finally happens in February 1996, where they realize, uh-oh, we have a constitutional problem. But then, crickets. The case entirely vanishes until October 1999, when the Constitutional Court basically stumbles upon it during an inquiry. So how exactly did this massive sequence of failures happen? The first huge failure boils down to 5 months. Under the Criminal Procedure Act, the clerk of the magistrate's court is required by law to forward the trial records for automatic review within exactly 1 week of the case wrapping up. But in Mr. Manyonyo's case, a total administrative breakdown caused a 5-month delay. During those 5 months, a man was literally sitting in prison, trapped in custody, based on laws that were likely unconstitutional, all because paperwork didn't get moved from one desk to another. Now, when the record finally did make it to the reviewing judges at the Supreme Court, they immediately spotted the danger. Realizing the presumptions used to convict him were highly suspect under the new Constitution, they stepped in to secure his release in February 1996. And get this, they set his bail at a remarkably low 10 rands. 10 rands. That nominal amount is basically a massive neon sign from the judges, indicating that this guy should absolutely not be sitting in a cell while they sort out the constitutionality of his conviction. Since the Supreme Court didn't actually have the final say on constitutional matters, they officially referred the issue over to the newly established Constitutional Court. But, you guessed it, the administrative nightmare continued. The Supreme Court registrar completely failed to actually lodge the referral order with the Constitutional Court. His paperwork inexplicably vanished into the bureaucratic ether for over 3.5 years. So while Mr. Manyonyo was thankfully out on that 10 rand bail, his legal status was floating entirely in limbo until the director of the Constitutional Court finally unearthed it after an inquiry in late 1999. Let's move on to Chapter 3, the constitutional clash. This right here is the core conflict at the heart of our explainer today. It's this absolute clash between outdated, heavy-handed laws and fundamental human rights. It's a total incompatibility. On one hand, you've got the 1992 Drugs Act, a statute deeply rooted in an era of presumed guilt and draconian enforcement. On the other hand, you have the new interim constitution, which explicitly guarantees every accused person the fundamental right to be presumed innocent, to remain silent, and not to testify. You just cannot have a legal system that simultaneously promises you are innocent while relying on statutes that automatically presume you are guilty just because you are standing near a substance. When the Constitutional Court finally got the case and reviewed the whole mess, the president of the court, Justice Arthur Chaskalson, issued a really sharp rebuke. He anchored this high-minded constitutional theory firmly back to the severe, real-world human cost of administrative delays. He made a fantastic point. It was incredibly fortunate that Mr. Manyonyo had been granted bail. Had he not been, he would have served his entire sentence just waiting for lost paperwork to be found. And that brings us to Chapter 4, the final verdict. When the highest court in the land finally issued its definitive resolution, it wasn't just a win for Mr. Manyonyo, it was a massive reset for the mechanics of the justice system itself. The court unanimously declared Section 21(1)(c) unconstitutional and invalid nationwide. And crucially, they applied this retroactively. That meant it invalidated any application of this presumption in criminal trials where the verdict happened after the interim constitution came into force. As long as an appeal or review was still pending, they systematically eradicated this unjust legal shortcut from the country's courts. But the court didn't just stop at striking down the bad law. They also laid down the law for their own court officials. Addressing that insane 3.5-year black hole, the court emphasized that under the 1996 Constitution, high court registrars are strictly required to lodge orders of constitutional invalidarity within 15 days. Not 5 months, not 3 years, 15 days. They made it explicitly clear that strict adherence to procedural time limits isn't just bureaucratic box ticking, it is a fundamental, non-negotiable requirement for delivering justice, especially for unrepresented individuals who have to rely entirely on the system working the way it's supposed to. As we wrap up this explainer, I want to leave you with something to really think about. Mr. Manyonyo's case brought down a terrible, unconstitutional law, for sure, but it also shone a glaring spotlight on the fragility of legal administration. If the system can literally lose a man's freedom in a paperwork black hole for over 3 years before the highest court catches the error, well, we have to ask ourselves, how many other cases, right now, are trapped in the shadows of bureaucracy? It's a stark reminder that true justice requires not just fair laws, but a flawless, accountable machine to actually enact them. Thank you so much for joining me for this explainer, and keep questioning the systems around you.